Al's passion to protect the community drove him to expose the corners that were cut during the construction of the O'Donnell Park parking structure, which resulted in a tragic death of his client, Jared Kellner. As a result of his work on that case, he earned the 2017 Robert Habish Trial Lawyer of the Year Award from the Wisconsin Association for Justice. Over the years, fighting for the rights of injured victims, he's earned other notable awards, including being named to the list of super lawyers every year since 2012, and recently being nominated and elected to the International Society of Barristers. He's also served his local community in Oak Creek as an alderman and was appointed interim mayor for a time in 2011. And he's been involved in other community organizations in Oak Creek, including the Library Foundation and the Oak Creek Little League. So Al, thanks a lot for joining us, and go ahead.
Thank you so much for having me. I'm a member of the Wisconsin Association for Justice, and we recently had a meeting where your organization had discussions with WJI, just talking about common threads, that beliefs and things that are important to our organizations that I think we can work together moving forward with. And I think then that kind of spurned this discussion, or having me talk to you all. So again, I appreciate you having me. And I do want to talk about limitations that some laws have on recoveries, on preventing recoveries. And I want to use the O'Donnell Park case as the factual scenario to talk about a specific law, to give you all an understanding of how laws can greatly affect people's rights to even pursue a claim. I think when people recall the O'Donnell Park tragedy, they obviously recall it as a very tragic situation because a 15-year-old boy lost his life. And I think there's almost an assumption that when we went to trial and got a significant verdict, that it was, I don't want to say easy, but that it was just meant to be, or was going to happen. That wasn't the case. It was a very, very legally challenging case. And I want to tell you factually everything, and then kind of bring it back to why that is. Why was this, in some respects, some have called it threading the needle, to even make a recovery in that case. So let me back up and just tell you factually what happened in the O'Donnell Park case. And I actually got to back up. The amount of tragedy around this situation, most people don't know about. There's many layers of how this case came about, how Jared Kellner, where he was when it happened. So let me back up. There's the Wozinski family. December of 2009, okay, the Wozinski family, Amy and Steve, have two sons, Steve Jr. and Eric. December of 2009, they lost their oldest son tragically in a car accident, okay? And obviously was mourning the loss, very difficult on the family. That brings us to June of 2010. June of 2010, so about 6 months after they lost their son, they lost their son in a car accident, and there were other people, other teenagers in the car that also lost their lives. June of 2010, the families decided that in the spirit of music and moving forward and coming together, they were going to go to Summerfest to meet up, celebrate their lives, obviously mourn their loss. But that brings us to June 24th of 2010. Those families decided to meet up on that day and went to the Summerfest grounds. While driving there, Eric, the one surviving son, texted Jared Kellner and said, "Hey Jared, we're going to Summerfest to celebrate Steve's life and the others that were lost. Do you want to come? And Jared asked his mom, Dawn, hey, can I go? He was excited, and she said, yes, you can go. And shortly after that, the Wozinskis stopped at the apartment complex in Greenfield that the Kellners lived. And Jared hurried out the door. It was kind of a quick goodbye. Eric was at the door. Dawn didn't want to, embarrass him by giving a hug or a kiss goodbye, and just kind of sent him off. And that's the tragic background of what brought them to the O'Donnell Park parking structure on June 24th, 2010 at approximately 4 p.m. The Wozinskis parked the car in the parking structure. Amy and Steve, the parents of Eric, walked out first. I just want to. So just to give you some context of where we're talking about, and I think everyone probably is generally familiar with, but this is, if you can see, this is the O'Donnell Park parking structure. I don't know if you can see my little, and this right here is ultimately where the panel fell. So if you look, this is the Lincoln Memorial exit, and this is where the Wozinskis and Eric and Jared walked out. Now, Steve and Amy walked out of the structure and were several feet ahead of Eric and Jared, who were trailing behind. Steve Wozinski heard a strange and loud noise from behind him and turned around and saw that the panel, this panel, had actually started to lift forward, kind of rotate forward. He locked eyes with Eric and Jared and saw terror because they were literally right underneath it. And unfortunately, the panel came down straight on Jared Kellner. Eric Wozinski, Jared's friend, he spun away with such effort that he actually broke his leg from spinning away, not because anything hit him, but because he knew it was coming, spun away to avoid being struck by the panel. The panel actually hit the back heel of Amy Wozinski, the mother, and Amy ended up losing her lower leg as a result of that injury. This is the panel on the ground, and you can see that it lifted away from the wall. These are architectural panels, just to give decorative architectural panels that were up. So we obviously had to investigate what happened. And the true tragedy of this, or another level of tragedy on this, is that this never had to happen. This absolutely never had to happen. And what we discovered was that there were corners that were cut in how this wall was put up. Let me share one other, just to kind of explain a little bit of what I'm going to talk about. Let me share one other screen here with you. This is actually from the Milwaukee Journal Sentinel, did a really nice graphic of how the panel was attached to the wall. So if you can see, this is the panel here, and there was a lip that laid over, and this thing right here is called the Parapet Wall. You can see these little black cups right here. There's 4 of them right there and right there. Those were steel cups. This is the underside of the steel cup. And so this little L shape, this is the side view of that. Well, these were engineered connections of this panel, okay? An engineer put these together, did all the calculations, wind, force, vibrations, everything was taken into account. So there were these steel cups that functioned kind of as the female receiver of a pin that would screw up into the top of the panel and then drop down into these cups. Okay. And then there was cement that was put in there to even firm up the pins as they were dropped down into there. And that's a key fact that'll come into play a little later. This wasn't done. None of these connections were made in the panel. When this was deconstructed, we had experts on the field watching every panel come down. On the Michigan side of the O'Donnell Park parking structure, the panels were put up correctly. There were the pins dropped down into the steel cups that were positioned between rebar, the engineered connection, and everything was grouted in place. When you swung over to the southeast side, you saw that the connections were made correctly, but then what we learned, or what the evidence showed, was that on each end, there was an additional, so say up on this end, there was an additional piece of rebar on each side that there was drilled in and then pounded down into the structure. And what our experts believe that was that these were put up by a crane, and cranes are expensive. So in order for the grout to set, when you put this panel in place, instead of sitting there and having the crane hold these in place, they would put these setting pins in on each side, and then they could move on to the next panel and get them up more quickly, okay? Perfectly legitimate way to do it. Other than the aesthetics, the county and some of their inspections weren't happy that there were these setting pins sticking up, but the underlying connections, the underlying architectural engineered connections were in place. These panels were solid. Move over to the east wall, okay? That's the panel that fell. Panel 56AL on the east side of the O'Donnell Park parking structure. None of those panels had any of the underlying engineered connections, zero. The panel that fell did not have any of these four connections. They had simply drilled down, it was called the drill and pound method. They drilled down and pounded a piece of rebar on this side, and they pounded a piece of rebar on this side. Okay, now this is a 13.5 ton panel, okay, 13.5 tons, 73 inches high, so just over 6 feet, 34 feet long, 13.5 pounds. That's 2 adult male elephants. That's 6 F1 pickup trucks. That's 10 Volkswagen Beetles. That's how much this panel weighed. And there were 2 pins holding it in on each side. Okay. One pin on one side was pounded down into this parapet wall, 2.9 inches. The other pin on the other side was pounded down into the parapet wall, 1.3 inches. That's all that was holding up a panel that weighed 6 F-150 trucks. This was a ticking time bomb. This was an absolute ticking time bomb. And Jared Kellner, unfortunately, was in the wrong place at the wrong time. So unfortunately, ACS, who was the defendant in this case, who made the panels and put them up, wouldn't take responsibility, or their insurance company, Liberty Mutual, wouldn't take responsibility for this. And we had to sue them. So imagine Dawn, who lost her son, had to go through the litigation process and learn all of these facts, 1.9 inches of rebar holding it up on one end, or 1.3 on one end, 2.9 on the other end, and then have to tell her, yeah, they're not taking responsibility. And you know why? 2 reasons. Number one, they're saying this was all done, it was okay. This was signed off on, the engineer said we could do this, which were lies, okay? But the bigger problem, and the issue that I bring it back to that I brought up earlier, was the Stature Repose. Okay, the Stature Repose at the time basically said, when a structure is substantially completed, and this structure was substantially completed, I believe in 1990, 89 or 90. After 10 years, you don't have a claim. If you get injured as part of the structure, there's no claim. Okay. And unless you can prove that there was misrepresentation, concealment, or fraud of the underlying defect. Okay. So number one, you had to prove a defect. Number two, you have to prove that it was misrepresented, concealed, or there was fraud in hiding it. Otherwise, you don't have a claim. And what ACS legally was arguing, Advanced Cast Stone is ACS, by the way. They were arguing Stature Repose. This is more than 10 years after the building was substantially constructed. There is no claim. Now, we survived summary judgment on that issue. We said that there was evidence that the fact that these underlying engineered connections were abandoned was concealed. And we proved, and we had evidence at trial that it was concealed. Now, the county was saying, hey, we didn't know about this. We had inspectors. Findorf was there saying, hey, we didn't know about this. We had inspectors. ACS was saying, give me a break. You could bend down and you could look underneath and see that those connections weren't there. Now, that's a stretch. But ultimately, at trial, we had one of the ACS. So James Coates was the foreman on the case. And he was the very first person we deposed. And he just lied. I mean, he said that, first he said, no, none of the connections were made. Well, we know that's not true. He said, yeah, none of them were made. The drill and pound method was approved by the engineer. That wasn't true. And we actually had an ACS employee take the stand and say, you know, James Coates told me that I just needed to drill in on each side and pound rebar down. I never in a million years would have done that had I not known the underlying connections weren't done. He never told me that the underlying connections weren't in place. You know, that was a very dangerous situation. So we thought our case went in very well to the jury. And given the tragedy and the huge loss, the damages part of the case, I mean, it was significant, but obviously you all can appreciate that losing a 15-year-old boy, there's no joy in getting a big damage verdict money-wise. It was more important to Dawn that ACS be held accountable after putting it through. Imagine learning all this and then having to sit at trial and hear about all this and how it could have been prevented. And you know, and being forced to go to trial on this. It was a terrible situation for her. Well, we got the verdict. It was a 9-page verdict. Okay. Let me show this to you. Judge Foley was the judge on the case. He did an excellent job. A very compassionate man. And I appreciated how he handled the case and did this. Now, this was not a simple who's at fault, what are the damages kind of thing. I mean, this is a 9-page verdict, tons of subsections. I think there's 29 questions. Okay. Well, because of the Stature Repose, the jury had to answer whether they believe that there was concealment or misrepresentation. If they found no concealment, no misrepresentation, it didn't matter who they found was at fault. It didn't matter what the damages were. The Stature Repose would have kicked this claim in the entirety. So the verdict actually was, the courtroom was packed. It was I don't want to say an electric atmosphere, because it was honestly like a kind of a gathering, like a sense of mourning to take this verdict in. The local news stations cut in live for the verdict, and Judge Foley went through, and I told Dawn, I said, look, the only 2 questions on this verdict that really matter are the last 2. So we don't know if we're going to win or lose until we hear what the last two questions are. So Judge Foley went through the verdict and we won. Advanced Cast Stone was given 88% of fault. And there was substantial monetary awards that were made, throughout the verdict. But then we get to the last question. Okay. And Judge Foley paused and the courtroom filled with people, and he started to say things, thank people for being here, thank everyone, thanks for the chief judge for being here, thank everyone for being patient. And we're literally waiting for these last questions to be answered. It was a difficult situation. However, thankfully, those questions were answered. Regardless of how you answered any preceding questions, did Advanced Cast Stone intentionally conceal a deficiency or defect in the panel installation? The answer was yes. Did Advanced Cast Stone misrepresent a deficiency or defect in the panel installation? The answer was yes. So we won. But those two questions that were answered in our favor show how delicate of a situation this is, that I don't think most people knew about or appreciate, that this family, the Wozinski family and the Kellner family, legally may not have had a right to recover anything or even bring this claim, because Advanced Cast Stone tried to get it kicked on summary judgment, given the statute of repose that exists. So I wanted to talk about that and talk about the tragedy and how delicate of a situation it can be when you have laws that are passed to limit people's abilities to bring claims, and what a slippery slope it can be. To make matters worse, the statute of repose was actually amended a few years ago to make it 7 years instead of 10 years. Okay, so it's even worse now. So if something happens after 7 years instead of 10 years, you've got protection as the builder, unless you can prove a deficiency or a defect that was misrepresented, concealed, or there was fraud. So that's the factual situation that I wanted to rely on to get across how these limitations, when you hear about arbitration clauses being put in place where people are agreeing to arbitrate nursing home abuse cases instead of being able to bring it to a jury, or different immunity statutes that we hear about all the time, and all these special interest groups that are working the back rooms in Madison, protecting their dollars instead of our citizens. And that's why, this case was so important to me on so many levels. I'm a Milwaukee boy. I grew up on the South Side. I went to Summerfest. My friend Steve Smith was a security guard at Summerfest and would sneak us in when we were in high school. We went almost every day. That was something that was so important to me. The lakefront, all of that. And then this tragedy happens, and to be put into a case and learn all this, and learn what was done. And I have to thank my partner, Brett Eckstein, who is a great legal mind who helps deal with these issues of statute of repose. There were other issues, whether we could get punitive damages, whether Jared Kellner had a fear of death claim because it was a short amount of time. Could he really appreciate what was going on? Was the jury going to be allowed to award damages for that? Ultimately, we won on both those cases. And by the way, there is a published Court of Appeals case upholding our verdict, our legally getting around the statute of repose, and upholding our fear of death claim as well as the punitive damage claim. So at least that exists in the law, but you really have to prove a lot. This wasn't, I think people generally hear about situations like this and don't understand that there are significant roadblocks that were put up years ago by, WMC or different building trades that protect those businesses instead of people that enjoy our lakefront. So that's the example. Let me tell you a little bit more about the other thing to consider is, let me show you this. So this is 895. This is where actually, I'll show you this in 1 second. This is a section of the statutes that has most of the immunity laws. Check this out. So 895, okay? Here's the index of 895. So this subchapter 2, exemptions from and limitations on liability. This whole right side, all of these are immunity statutes. There are special interests that have gone to the legislature and campgrounds. 895, 519, civil liability exemption for private campgrounds. There is immunity statutes regarding recreational activities. I mean, one of the most egregious cases that I've come across over the years is a beach in Kenosha where they had hired lifeguards and a boy drowned, and the litigation, it came out that the guards were not trained. They had no lifeguard knowledge, none whatsoever, and the case was kicked on recreational immunity. There was nothing that that family could do regarding the death of their son. So I raise these as examples of the slippery slope and how this affects real people. You take the Stature Repose, for example, and that literally could have shut our case down in O'Donnell Park. And that mother would have had no recourse. Again, put aside any dollar recovery, because I can tell you the money of that case was hollow. She wanted ACS to be held responsible for the death of her son. And to some extent, that verdict provided that, because we quote unquote won. And we could have easily lost that case early on, given the Stature Repose. So I think I can open it up to any questions now. I've certainly spoken long enough, and I appreciate you. As I've been asked to talk quite a bit less now, because this unbelievably, the O'Donnell Park tragedy happened over 10 years ago, and we tried the case in November of 2013. So we're going on 8 years. It's crazy that it's been that long, but over the years, I've been asked to speak quite a bit on this case, and I enjoy doing it only because I want people to understand that, there are practical, real implications. I mean, this was Dawn Kellner, the mom of Jared Kellner, went to grade school with my uncle. She went to the same church that I went to on the south side on 34th and Parnell. This is a real person that the statutes that the mostly generally the Republicans in Madison are protecting special interests instead of protecting our society, our community that I value so much. So I'll open it up for any questions, any comments that you would have, and certainly appreciate the time talking. Thank you.
Thank you, Al. And again, just if you have a question for Al, please either use the raise your hand feature in Zoom or just type in the chat box that you have one. And I see that Gretchen has a question. So go ahead, Gretchen. And in the meantime, everybody else who has questions, just type your name in or just say, I have a question in the chat box.
I don't know why this topic popped into my mind now, just in the middle of the night, out of nowhere. What's your opinion, and what do you see as the outcome of using private actions to enforce unconstitutional laws?
Okay. Couple reactions to that. Number one, kind of going back to the O'Donnell Park cases, early on, we were faced with believing that the Stature Repose is unconstitutional, that it's not equal protection. It protects some manufacturers different than other manufacturers, and we had to make a choice. Now, 5 years before O'Donnell Park, the Wisconsin Supreme Court upheld it as constitutional. So we had to make a choice. Were we going to challenge the constitutionality of that law, or were we going to do what we ultimately did, was use the exception? Because honestly, given the makeup of our court, even back then, they were not going to go out of the way for a common citizen. There was much more sympathy for, the business, corporate side of it on the Supreme Court. Now, this is coming from someone who you probably heard in the introduction. I was Justice Prosser's first law clerk, who's a known conservative. Now, coincidentally, when I clerked for him, he was very close with the chief, well, I always call the Chief Abrahamson, Shirley. Amazing, just amazing woman to work with and get to know. And they were very close, and then things went off the rails years later. But the court in Wisconsin, as far as the constitutionality of some laws, we had to make the decision of, were we going to challenge, even if we could win it at the circuit court, even if we could keep the constitutional or win a constitutional argument or unconstitutional argument at the circuit court and in District 1, the likelihood of that being upheld with our Supreme Court makeup, which is worse now, was unlikely. So we chose to go down the path of using the civil recourse and using the exceptions of the Stature Repose rather than challenging the constitutionality.
Can I follow up on that?
Sure.
I was thinking specifically of the Texas abortion ban.
Yeah.
And having a law enforced through private lawsuits.
Yeah, and absolutely, that is certainly sometimes the route you have to go, and you have to, unfortunately, because the legislature can politics now, and we all know that politics has unfortunately crept more and more into the judicial branch. And I honestly can say, because I spend most of my time in the trenches in circuit court, I don't see it as much, to be honest with you, in the circuit court. I even judges that are quote unquote conservative usually call balls and strikes, and there's not overt politics. I think the higher you get up in the judicial system, I think there's more of that. And that's so unfortunate. So, in the case of the Texas abortion law, there could be a choice to challenge, when does it's 6 weeks? Is that the law that was passed? When does that start? Is there a gray area in that? I mean, there's that part of it, but certainly if you can't if the legislature is so stacked against you, the private civil courts is the way to handle a case like that. You have to do it, and you have to have the ability and the willingness to pursue something like that in the court system, and hopefully have a court that will put politics aside and decide things on the law.
Jim Gramling, go ahead.
Al, you mentioned an amendment to the statute, and if I looked quickly and accurately, it appears that the change in the statute occurred as part of the 2011 budget bill. It may have at least. Did you follow the amendment process to 89507 and have an opportunity at the time to see who was pursuing the amendment?
We did not. Well, you know, we actually, Dawn Kellner testified at the hearing for that. We sat there all day, and she was one of the last people to be allowed to testify about that amendment. And as tragic as it was, there was a representative, is it Andy Jorgensen? I don't think he's there anymore. Who was a Dem who afterward came up to her this long day, came up to her and gave her a hug and just said, "I'm so sorry that you had to go through all this. And I'm so sorry that you were literally one of the last people behind all the lobbyists to testify regarding this." And she still brings that up today. So yeah, you know, unfortunately, it's frustrating when you literally see the corporate backroom work deals being done that affect the people that were sitting right next to me at that hearing.
Lauren Blumenthal, go ahead, unmute.
Thank you. One of the questions that I had that I think is germane to the O'Donnell Park issue, I will acknowledge this is a matter that it's close to home personally and professionally. Along like the waterfront areas of the city of Milwaukee, in particular the riverfront, like the Tannery Road district and so forth, where there's been a lot of development, exponential growth development. But I know from personal experience, like my condominium building was a $10 million remediation because the soil grading was not inspected properly by the city, the municipality. There was not enough drainage, and ostensibly we had to put metal girders in because the place was about to collapse into the river. But as they keep developing more and more, you know, large developments, both dual zone commercial and residential, if it's the municipality's obligation to oversee the, you know, the dredging of the, you know, forever chemicals or heavy metals in the soil and the water, and then in advance of laying the foundation and overseeing that protocol, are you running into any liability considerations where that sort of qualified immunity from the city's standpoint, as well as exactly what you were saying, sort of backroom deals, and, you know, let's just shove this under the rug, has become an issue or an impediment in advancing litigation in these matters?
No, and that's not necessarily a pond that I swim in. I did try a 7-week case against Waste Management years ago involving contamination from a landfill, but I don't know the ins and outs of that side of the law. What I can tell you is that my experience in being involved in city politics in Oak Creek as an alderman for 9 years and then mayor for a short time was that staff was diligent. I can't speak for the city of Milwaukee. I mean, I'm talking about Oak Creek, which is a different animal, but staff was very diligent in trying to do the best thing. And obviously developers try to make as much money as they can, you know, and they try and spend the least amount that they can. How that transforms on the liability side, and if there's any qualified immunity or anything like that, I'm not exactly sure on the development side how that would take place as opposed to on the personal injury side of it.
Just super briefly to dovetail off of Gretchen's question, do you have any concerns, and I mean this with all due respect, but we have a very young and new judiciary, many of whom have served perhaps exclusively in the role as a prosecutor, never in civil litigation, for example. Do you have any concerns about presenting these actions that are very complex and involve matters and areas of law that if you've never had any experiential or contextual understanding or frame of reference, and you've got a very young or new member to the judiciary, that these issues would necessitate perhaps, you know, special master to oversee the discovery or evidentiary issues or other considerations of that nature, especially with the evolving leadership on the.
Yes and no. I do believe that there was a consideration, or there may be, that there were special corporate courts suggested in Wisconsin in some counties. The upside of that is expertise. The other side of that is that you could, I like getting new judges rotated through different experiences, different backgrounds, working through cases. I think that's a good thing. I can tell you though that the hard work is finding good, progressive, caring people to enter the judiciary, because dollar-wise, I think private practice is more rewarding dollar-wise. And I think that there needs to be an effort in the law schools to recruit. And I know WAJ has teamed up with ACS, American Constitutional Society, to try and work to promote, judicial candidates that are young and progressive, because certainly on the right, in the Federalist Society, they are recruiting like mad and they are grooming. And, you've got a lot of young white guys coming up ready to take the mantle of this conservative Federalist movement. And there is an effort to do the same on the progressive side, to try and attract people and let them know the value that they would bring to that. Now, having said that, again, like I said, at the circuit court level, I've had generally good experience with judges. There are a few exceptions, but generally it's the higher level courts that concern me. It's the makeup of the Wisconsin Supreme Court, where it's just overtly political right now. That concerns me, as far as getting people to move up through the ranks, getting a young progressive minority, for instance, to take a judgeship in Milwaukee County and then work his or her way up to the Court of Appeals and then ultimately run for the Supreme Court. I mean, that would be a great way to build, because I'm biased, but I think on the higher level courts, the progressives call the balls and strikes more as balls and strikes. I could, maybe that's my rose-colored glasses, but I think that's what we need to do to work towards getting young people that understand the issues and are caring. That goes a long way. When they care about people on the personal injury side of it, that goes a very long way. Even in the way they interact with people. I can tell you Judge Foley's demeanor and interacting with Dawn Kellner was important to get through a 6-week trial. It just was. And I thank him to this day for that.
Al, I have a question about Wisconsin Association for Justice. And so we've got the lobbyists, so many lobbyist groups for getting these exclusions and caps on liability. And, what is Wisconsin Association for Justice doing, and who are they working with, or who should we pay attention to for alerting the public about these before they become law?
Well, I think that's one of the hopes in teaming up with WJI, that we can work together to alert our different constituencies to things that are going on. We have a lobbyist, Joel Stroll. We actually work with a Republican lobbying firm as well, just to face the realities of the legislature in Wisconsin. And we fight like hell when there is any type of immunity statute proposed, because of the slippery slope that it entails. And we work hard to prevent as many as possible, just because we just don't want the snowball effect and having that affect the people that represent us. Here's another reality of these laws. The law in Wisconsin put the value of Jared Kellner's life to his mother at $500,000. Now, that's the cap. That's for a minor. If a parent loses a minor, the law in Wisconsin caps a wrongful death claim at $500,000. That's it. That's what Suits and Madison's decided years ago. If you're an adult, it's $350,000. That's just the reality. Now, there was a larger recovery in that case, and that's why when I mentioned the fear of death claim, the 3 to 5 seconds that Jared Kellner would have known that his life was in peril and the terror that Steve Wozinski saw in his eyes before that panel came down, the jury awarded $6.3 million for that. Had that award been kicked out to say there wasn't enough time, or said that was an excessive amount of money awarded for 3 to 5 seconds, Don Kellner would have been left with $500,000 and a dead son for the money that ACS saved to be able to move the crane quicker along the east side of the building. So those are the types of things that I don't think people realize. Now, if you have a medical malpractice case, or a wrongful death case, and there's only surviving siblings and they're adults, there's no claim. The law in Wisconsin says there's no wrongful death claim for adult siblings if there are no parents. Nothing. That's a legislative decision that was made to take away our ability to not only recover dollars, but hold someone accountable. And that's truly what it was in Dawn's case.
Bill Lynch, go ahead.
I think that what is really challenging in this area is figuring out how to articulate what the issue is in easy to understand terms to the general public. A lot of the immunity issues that you showed us on the statute have to do with environmental harms, as well as, and we have, of course, the immunities that are associated with police recovering for police misconduct and those other things. It seems to me it would be worthwhile to figure out a way to generally educate people about the function of these matters. And it's not easy to come up with 10 words or less explanation.
Yeah, it's bumper sticker politics, right? I mean, that's what it is. And I think in this situation, when I'm faced with a conservative Republican, arguing about these things, what I say is, look, aren't you the ones that are pounding on the Constitution and saying, it's strict construction, all that? I said, what is more American apple pie puppies than a jury trial? Why are you taking that away from people? Right? Why can't 12 people in Milwaukee County decide what happened in O'Donnell Park was right or wrong and what the loss is in that case? Why take that away? Right? I mean, that's what you're doing. You're taking that away. So if you want to pound your fist on the Constitution, what is more of the face of the Constitution than a right to trial? And you want to take that away. That's just wrong.
But it seems to me that in the case that you brought it to our attention, it is, of course, a concern for the victims to not have accountability. But what's even more important is to have structures that the public comes into contact with safe. That's the broader issue, and the ability to secure damages when they aren't safe is part of making sure that future other places will be more safe.
Right.
So it's that function of civil liability that I think is lost. I think if we just talk about getting large damages for harmed individuals, that feeds into this is the Trial Lawyers Association argument. Well, thoughts.
I agree with you. That is dangerous, and that's why when I talk about O'Donnell Park, I don't necessarily talk about the damages side of it, because, like I said, that is hollow. It is. I mean, Dawn Kellner could have cared less what the dollars were. She wanted to hold Advanced Cast Stone responsible, and that's why. And when I have an opportunity, or I did more often years ago, to talk about this case, I took it because I wanted to explain to people that is important. To not take that away from people, the right to seek justice and hold people accountable is important, not only in that case, but I can tell you it's important to Dawn to hope or think that, you know, a $15 million punitive damage award, even though that's a heck of a lot of money, that is going to resonate in whatever WMC newsletter that goes out talking about the verdict. And maybe you're not going to have a James Coates say, you know, well, you know, we can save some money and move the crane quicker. I mean, certainly that was the goal of that case, was taking the opportunity to protect our community and sending a message. And that's exactly what I told the jury in closing argument. You have a unique opportunity with this punitive damage award to send a message to other manufacturers out there of not only, you know, architectural panels, but just generally. Do it safe, do it the right way, don't cut corners, protect our community.
Gretchen, you had another question. Go ahead and unmute.
I do, thank you. I have two. You can pick and choose or whatever. First one is, has anything good happened in Wisconsin law for plaintiffs in the last 10 years? And the other one is, how do you see climate change impacting civil litigation?
Anything good in the last 10 years? So, I don't think so. There was, and that's more than 10 years ago when Governor Doyle was governor. They passed a truth in auto legislation that fixed a lot of misunderstandings with respect to insurance coverages. I won't get into the weeds on that. You know, and that held up for, I think, a couple of years, and then the Republicans took control and took it away. So, you know, what coverage they thought they had was corrected for a couple year period, and things reverted back to the old ways and protected the insurance companies instead of the individuals. With respect to climate change, you know, that's probably a dangerous defense that exists to say this is an act of God situation, as opposed to something that, you know, that a manufacturer or builder in the O'Donnell Park case came about. I mean, we faced, as part of the defense in O'Donnell Park, was that there was an earthquake that was registered in Milwaukee County around the time of the O'Donnell Park tragedy. They tried to say it was that. I mean, Jesus, it wasn't. I mean, you know, and if put together correctly, it wouldn't have fallen off regardless of even if it was that. So I think that could actually, with climate change and more dramatic climate change, there could be some defenses that come out of that actually for insurance companies.
Are there any more questions? If so, you can just raise your hand on the screen. All right, then with that, thank you so much, Al, for joining us and talking today.